Welcome to Who Shaves the Barber, a weekly podcast where we explore paradoxes, thought experiments, and other pointless problems. I'm William Nava. All right, I'm super excited for today's episode of Who Shaves the Barber. I have with me probably my oldest friend, period, and one of my closest friends, Michael Zigismund. So, Michael Zigismund is an attorney, and he is something of an expert on jurisprudence and the philosophy of law. And Michael Zigismund and I, we've been friends since, freshman year of high school. And he is the person who got me interested in political philosophy in the first place. One of the stories that I love to tell people is when people ask me, how did you come to the views that you have on political philosophy now? My answer is basically that I reached those views through discussions over many years with Michael Zigismund. He and I in high school were both neocons back in the Iraq War era, and through just many conversations and email exchanges, eventually and gradually turned each other into radical libertarians. So the subject that I want to talk to you about today is jurisprudence and philosophy of law. So again, first of all, thank you for being here.
Thank you for bringing me on.
All right, so let's get this started. So philosophy of law. Let's first kind of dive into what seems to me like the most fundamental question here, which is, what is the law? So do you have any of your ideas about what the law is? Are there any major sort of foundational debates about that question, about what law even is?
Yes, very much so. I do have a sort of answer, but just the basics is that's quite possibly the biggest question in all of the philosophy of law. What is law as a thing? As far as I'm concerned, it's an institution that we all enjoy, that we all deal with. It's kind of like oxygen. It does give us the rules of the game, the rules of our lives in a certain sense, but not always. It's related to other rules. Like, for example, if you have etiquette, like just basic table manners, that sort of thing, that's not the law. They are maybe rules in a certain sense. The law is related to those kinds of rules. The law looks a lot more like police officers and courtrooms, statute books, that sort of stuff. That's not what you're going to find in etiquette. However, it is related to etiquette in that they are still rules that have to do with your life, and it permeates everything that you do. That's the law. The law is an institution that operates alongside of life in every single nook and cranny of what life is. That's about the broadest possible definition of what law could be. Then the next question is, if you're going to pass a statute or something, could it legitimately be a law or not? And then all of a sudden, experts, scholars go haywire, and they start debating about what really constitutes, what are the characteristics of law specifically. And then all of a sudden they get into all these really minute debates that I think are extremely interesting, that a lot of people who are into philosophy, who are even into political philosophy or ethical philosophy, are not particularly aware of, but I think it's fairly crucial to some of these debates. Anyway, you want me to give you some examples?
Before going to an example, I want to ask you. So, when I ask myself, without thinking too much about it, just what is the law? I tend to associate the law with statutes. With what's in the legal code, let's say. And I think that's probably true for most people. Do you think that there's more to the law than what the legal statutes say, or is that is there a point of view about the law that says that it's more than just what's written down in the legal books?
This is a really softball question. The answer is absolutely yes. There's way more to the law than just what is a statute or what is in the legal books. Well, first of all, like what is in the legal books? You have statutes. Statutes are those rules, those commands that are created by a legislature that is signed into law by a president or is created by an assembly, signed into law by a governor. So those are statutes, and those are in the law books. There are other law books that are written by, let's say, judges. Judges have litigants and whatever litigation before them. They have to make an opinion. They have to say, you win this case, you win that case, and then they write out the opinion. And whatever goes into the opinion are a bunch of expressions, opinions on what the law is. That goes into the law books as well. Then you have administrative agencies, and they write their regulations, like the EPA or the FDA or the Department of Education. All these agencies create their own particular rules, their own particular regulations, whether for themselves, like how do agencies operate, or for people, for you and me. All of that could be thought of as the law, like under your definition of statutes. Although statutes are specifically what the legislatures write, all of that can be thought of as maybe perhaps what does the state create as law. Even there, that is not the entirety of law. There's a whole other world of law that takes into account like what is allowed to be written in those statute books. And that all of a sudden opens up this massive world of morality. Like, what is a society going to say about a certain statute when it's written into the law codes? Is the society going to recognize that statute or not? And now all of a sudden you have to look outside of a statute into what is okay for society? What are the basic ethics of a particular society at a given time? And then all of a sudden you are talking not just about what is written down in the law books as law. You're talking about something way bigger, also as law.
Okay, so besides what's written down in these various different kinds of legal books or statutes in that broad way I was using it, that I guess was wrong. Besides all that, you're saying that there's like maybe just implicit understandings of what actually can be written down in those things, and those understandings are also part of the law?
Yes, I'm not so sure if I would call it implicit understandings. I would think of it more as morality, which could include implicit understandings. Like you have any particular person has intuitions about what is moral. Those intuitions are, I guess, implicit understandings. There's also like customary dealings. Let's say in the world of commerce, commercial law. You have businesses that deal with one another in a certain specific way in this area of commerce, in that area of commerce. And in those particular specific areas of life, there are, I suppose, implicit understandings, customary understandings. That all can be thought of under the banner of custom, or it could be morality. Implicit understandings, I guess so, but I would think more in terms of custom and morality, or morality.
In this conversation we're having about what kinds of things count as being part of the law, where does common law come in? Can you say, first of all, what common law is and how it fits into this?
Yeah. Common law is often understood, I think wrongly, as customary law. Customary law is just basic customs where rules emerge out of just dealing after dealing after dealing, whether before certain law courts or in the marketplace or whatever. That's customary law. That is not it can be formal, but it's not necessarily formal. Customary law. Common law is often thought of in that sense, that it's customary law, that it kind of comes from the people, like the common people, the common law. And I think that's a cool, helpful way of thinking about it. But just to be specific, that's not common law at all. Common law is actually the king's law. Like it goes back to England. The king set up these courts for the people. You go to those courts for the king's particular legal outcomes. That's the common law. And then it then melded with whatever other customary laws there were, whether it's like religious courts or town courts or commercial courts or manorial courts, like on manors, feudal manors. That all mixed into this great big behemoth that like started small and then became big, that is actually called the common law. And then you had the New World was discovered, the legal system came over from England to America, and then all of a sudden American jurists started saying, well, we're going to be applying the common law of England. And that came over like with this, at least today, with this kind of mythology of common law came from the people, where it really didn't. That's where common law comes from. With that said, although common law is not customary law, again, there is much more to law than just what is on the statute books. And understand the common law was significantly influenced by what is and should be properly considered customary law. So I think of common law as both the king's law and something that is significantly influenced by customary law.
Okay. All right. That makes sense. All right. So can you now tell me about some of these important debates that come up when it comes to interpreting, what kinds of things can actually be put down in legal books and the statutes.
I think the most obvious debate is the one between positivism on the one hand and natural law on the other. It's the most obvious that comes out of the discussion that we're enjoying right now. Positivism is the one that says whatever is on the statute books or the law books, that is the law. Sometimes people call it the command theory of law, that when the agents of government command something, and I guess it doesn't really have to be on the law books. It could just be like commanded from, a person like a police officer's mouth, like I order you to stop or something. That would be positive law. That's positivism. It's like this really narrow view of the law, and that's exactly what I was critiquing from the beginning. That's not law.
So when I said, that like the intuitive idea that I had of what the law is just what's put down in all of these various statutes, that would be kind of like the positivists' view on what the law is?
Yes.
Okay.
Yes. Okay. On the other side is like everybody else saying, well, there has to be certain limits to what a particular political actor or legal actor could say or write down is the law. Like, it's not the case that the president can make whatever law the president wants. There has to be certain limits. There are, by the way, limitations, like constitutional limitations, like he has to ask Congress for permission, that sort of thing. But like, suppose everybody gets together, law comes out, people say there are still limitations, moral limitations or customary limitations on what can go into positive law. And that's where the natural rights or natural law tradition comes in. I should say that there are a lot of competing arguments outside of positive law. As I said, like some of them are moral, some of them are customary, some of them are other. The big kahuna in this space, however, for several centuries has been the natural rights tradition. That's just one kind of morality, but it's been extremely influential. So that's why I say that the big debate here is usually between positivists and natural lawyers.
Okay. So say a bit more about that debate. Like, what are some of the justifications that natural rights, the people who advocate for natural rights approach, have against the positivist?
Well, the big idea is there has to be certain limits on what the agents of government can actually give us as what is law. Like, certain things are just beyond the pale.
So I guess
I'm thinking of examples.
but before going to examples, I guess the thing I
Sure.
want to ask is like, from what source would those limitations stem? You know, like if the idea is there have to be these kinds of limitations, I guess that idea is intuitive enough. But then, you know, what is this? Where do we get what those limitations should be from?
That's a huge question. Like, where do revolutions come from? Like, how do you get political reform movements happening? Like, that's a big question in the world of politics, political history, that sort of thing. It could be outrage. Like,
Well,
I'm outraged that is. Mhm.
sorry, I didn't mean quite where do they come from? Like, how would that come about? I guess I'm thinking more justification wise. Like, what would determine what should be those limitations? Forget how we're actually going to get them, you know, implemented. Like, what determines what those limitations should be?
Mhm. I think it would be helpful to go into an example and then go from the example backwards.
Okay.
We could start with take your pick: slavery, Nazis, or guns.
Ooh, fun. Okay, let's. I watched *Inglourious Bastards* a couple nights ago. Let's go with Nazis.
All right. So this happens to be one of the probably the most famous example arguments in the world of natural rights versus positivism. It might be the most famous one. Is Nazi law law? Like, you started this discussion with what is law? Is Nazi law law? Well, first of all, suppose that Nazis create a regulation like alternate side parking is in effect from a certain time to another time. Like, most people are not going to be outraged by that. That's kind of like, okay, we might have a problem with the fact that there are Nazis giving us these laws, but the law itself is like, okay. But I'm talking about like legit Nazi law. And the case that was brought up was, I forget, but it's something along the lines of if somebody is rewarded or not punished, whatever, if they give up somebody as a Jew to the Nazis, something like that. Like, just something really, really terrible during the time of the Holocaust. Like, can you sue that person? And the answer would be like, no, something like that. And if the rule is no, like, you're totally immune for doing something totally heinous like that, that's a Nazi law. Is that law? Well, before 1945, in occupied territory, if that is on the statute books, a positivist, like a strict positivist, would have to say, yep, that's most definitely a law. Not only that, but given that it's a law, like, what does it mean to be a law? It's legitimate in the sense of, like, these are the rules of the game. A natural rights lawyer or some sort of other moralist or something outside of the positivist tradition might say, well, hold on a second, that kind of sucks. It's a really, really bad law. We might have certain problems with that. First of all, I don't like it. I can line up many millions of people, other people who would disagree with it. Not only that, but if we have other laws like that, after a certain period of time, that might actually cause chaos because these rules are just so obviously immoral that it would just like undermine the social fabric, that sort of thing, such that it's not law. Like, if the law doesn't protect the social fabric, social stability, and is frankly obviously immoral to most of us, it cannot possibly be law.
It kind of sounds like there's a very fundamental difference between the positivists and the natural rights, which is that they disagree. It seems to me, regarding the nature of what kind of thing law is, and here's what I mean by that. One side seems to be offering something that's descriptive, where another side seems to be offering something that's prescriptive. Like, it sounds like the positivists have an attitude that's just like, I'm not here to say what's good law or bad law or what should be the law. It's just like whatever it is that the people are doing, that's the law. You can read it. And the natural rights are saying you can't sort of separate the law from what the law should be. Would you say that that's accurate?
Totally. This is known as the separation thesis. Separation theory? Thesis. A thesis between morality and the law. That they are two separate things. Do not allow them. If you mix them, all of a sudden you muddle things and you confuse everybody. This debate, this is Nazi law debate, for you or for anybody else who's interested, is between these famous theorists in the 1950s, Lon Fuller, natural rights guy, and H.L.A. Hart, positivist. Hart's position is you have to separate morality from the law, period. Then once you know what the law is descriptively, as you say, then it can be reformed. Like we can be clear about what the law is, then we can reform it with these outside ideas of morality. Lon Fuller would say, on the other side, would say there is no separating the two. I think he called it the coherence thesis, that they're actually one and the same. They are together. I seem to recall that he never proved that, but that was his position, that they are one, they are inseparable. I think I could argue for the both of them. Like, frankly, analytically, there's law on the one hand, there's morality on the other. That's kind of obvious. On the other hand, law as an institution, like I introduced the law as a social institution that is just here. It's the air that we breathe. How do we separate morality from the law if it's the thing that is there in every part of our lives? How do we compartmentalize morality from our lives and law from our lives? Like we're living one life, we're living one society. How do you actually do that?
Yeah. So when it comes to somebody who's for natural rights, somebody like Fuller or anybody on that side, what's the difference between not a law and a bad law?
Legitimacy, I think. A bad law is still legitimate, that we should follow it, we could try to change it, whereas not a law that's just an illegitimate law. An interesting question might be raised. I haven't thought much about it, but recently Jeff Sessions has reinstituted the possibility of federal prosecution for recreational marijuana in those states where recreational marijuana is actually legal according to the states. So the states say recreational marijuana is legal. The federal government at the same time says recreational marijuana is illegal. Under Obama, Obama's Justice Department said we're not going to enforce the law in these states where recreational marijuana is legal. And Jeff Sessions just this week said, I'm turning that back. If federal prosecutors want to prosecute in those particular states, I'm not going to stand in their way. Mm-hmm. And a lot of people think that he's actually going to push them to prosecute in those areas. That's an open question. But the interesting question that comes out of that is it legitimate for the federal government to prosecute rules and regulations that in a state where the state said, do not prosecute this stuff here? It's illegitimate. It's not just a bad law. It is illegitimate. Or is it legitimate? Mm-hmm. Is federal regulation in those states where marijuana is legal, is that legitimate and a bad law? Or is it just plain illegitimate and something that should not be followed?
So it sounds like there's two possible questions here, which again would seem to be kind of like which question you would be more interested in would maybe depend on whether you're a positivist or whether you're a natural rights thinker. But you could ask, well, what are the relevant issues, the relevant like federalism issues here? What are the relevant issues regarding the relationship between state laws and federal laws? Well, what does the Constitution say about the relationship between federal laws and state laws, or what do important Supreme Court decisions say about federal laws and state laws? because, well, that's in terms of on the paper, that seems to be very relevant. Whereas another question might just be, what is the moral legitimacy of, some group of people going through a legal process and deciding that something is legal, and then, some larger mechanism or group of people, going through a legal process and deciding that this thing is actually illegal, and one is sort of like embedded in the other. What is like what's the like morality of that going on? So, I mean, does that sound right to you? Those two approaches would be how a positivist or a natural rights thinker might approach that?
Yes. As always, it's what you bring to the table. It's your ideological priors. It's really the questions that you ask that are on the forefront of your mind that then determine where you come out on the positivist versus natural rights position. Yes. I don't really have much to add to that, but I would like to get back to the question about where the morality comes from.
Yeah, go ahead. Please do.
Yeah, so where does the morality that these these Nazi laws are bad actually come from? Like, I think that most of the people watching at this point in time, 2018 now, would be very much against those kinds of Nazi laws. But then the question is why, and that the question of morality should really stretch back for many centuries and millennia. So we're not going to answer it here, and I promise you that no jurist has ever solved the question of where morality comes from. But I do think that it is really fascinating. This is why I wanted to go into an example. I think it's really fascinating to look at what Lon Fuller is talking about when he's talking about how Nazi law is illegitimate. Because he seems to talk out of two sides of his mouth. Like, he justifies what is moral from two different places. One, he justifies it from the regular moral arguments, like something is bad, something is good, something is just, something is unjust, morality. On the other hand, he also talks about social stability. And that seems to not be particularly moral. That seems to be like consequentialist, which has its own morality, but it's more like, what are the outcomes that we want? Do we want the stable society? Do we want a society that is coherent, that you can like follow? So the legal rules give you certain expectations so that society can follow it, and everything is stable and nice, and we have a nice society. Versus what is good and just and proper. He talks about the both of them. I also and by the way, on the second prong about like what is stable, what creates a stable society, he talks a lot in terms of custom as well. So he throws in what is customary into his whole big conversation about what is moral. Mm-hmm. And as I mentioned before, I don't think that there's a way to really separate them all. I'm not entirely sure that Lon Fuller, at the time that he was like dealing with this particular debate, that he was aware that he was equivocating, that he was conflating all these different topics under his banner of natural rights. But I think it's frankly a really natural place to be, where you just like throw in everything in the kitchen sink to say something along the lines of, this law, this positive law, is bad. For many, many reasons, and we should not follow it. That, I think, is fundamentally the big debate, the anti-positivist debate.
Mm-hmm. So, I want to know. I want to hear your thoughts on, to what extent is this more than just a semantic issue? And here's what I mean. Here's why I'm thinking it could be a semantic issue. It doesn't sound like the positivists think that, or necessarily think that there is no such thing as morality, or that we shouldn't care about morality when we're drafting laws. It seems like they're saying simply, let's just, what we call the law, let's just have that be the sort of restricted thing of what's actually in the books, and then we can use morality to determine how to best sort of put those things together. Whereas their natural rights thinkers seem to be saying, well, look, what the law really is more than just in what's in those books. So it starts to sound to me like there's not that much substantive difference than how broad or narrow should our definition of the word law be. So what do you think about that? Is there more to this than just a question of the definition of what the law is?
It depends on the context. Sometimes it is, sometimes it isn't. So certainly there are certain cases where if you separate law from morality, you're still dealing with morality in a sphere that affects the law. In which case, like the separation thesis doesn't really do much to actually separate out the two. With that said, there are certain contexts where it really matters. For example, let's talk about guns. The Second Amendment is in the United States provides or protects the right to keep and bear arms. Just protects gun rights. That's the basic idea. And suppose you're debating about guns. Should you or should you not be allowed to own guns? Do you have a right to own guns? That sort of thing. I cannot tell you how often people say something along the lines of, it's in the Constitution, therefore we have a right to own guns. That's a clear positivist argument. Mm-hmm. It says so in the document. Law. It's a law. We have the right. Mm-hmm. And issues of morality don't come in. But you know that for those very people, that if there was nothing specific in the Constitution about it, they would still be arguing, we have a right to own guns. It's moral. It's a good thing. Mm-hmm. Customary. It's my tradition.
Okay.
And that really bothers a lot of people, especially people who are like against gun rights or for gun control, that sort of thing. They're like, gosh, why would you stop talking about the Second Amendment? Like, talk about what is actually right and good for society. Mm-hmm. There's a clear distinction there between law and the statute books, law, positive law, and morality.
It sounds like one area where the difference may be really significant is with regard to how we deal with illegitimate law, right? So do you think that an important application of this is that if you're a natural rights thinker, it sounds to me like if you're a natural rights thinker, you're going to be a lot more okay with saying, if I have a reason to think that some law is illegitimate, then I am 100% within my rights to ignore that law. Whereas a positivist might be a lot more hesitant to say something like that. Would you say that that's roughly accurate or not quite?
I think so. And one of the great arguments against positivism is exactly that. It's kind of like an apology for authoritarianism. Mm-hmm. Positivism is an apology. This is an argument against positivism. I think there are some problems with that. I think in a sense that's true, at least in terms of like the tendency is sort of inherent in positivism. Like it says it's on the books, we got to follow it. Like in the Nuremberg trials, the big idea was just because they gave you a command doesn't mean you need to follow it. In fact, your duty as a soldier is not to follow like clearly genocidal commands, that sort of thing. Where was I going with this? Ask the question again.
Well, I mean, I'm asking about the attitude towards like ignoring illegitimate laws.
Authoritarianism. Mm-hmm. Yeah. So obviously, like the Nazis in this world were authoritarians, and the positivists, the strict positivists would say, follow the authoritarian there, just follow it. So I think inherently there is a tendency towards authoritarianism in positivism. On the other hand, there are all of these examples of positivists being very much anti-authoritarian. Like actually in history, all of these like moral thinkers are not necessarily think Bentham was a positivist, and for a significant portion of his life was very much like liberal, reformist, that sort of stuff. On the other hand, there are all these moral thinkers who are saying that the law should be not necessarily what it says, but it should be something else based on some other morality that just happens to be authoritarian.
Right.
So I think it mixes and matches, but I honestly can't help but sense that the tendency in positivism is indeed authoritarian. Like, I can't shake that despite the history. That's just me.
It seems like if you're a strict positivist and you kind of want to separate morality from the question of what's the law, then you should perhaps be able to say something like those terrible laws that Nazis had, let's say, those really were laws. And that was genuinely and legitimately the law. And yet morality is a separate question. So you may have been perfectly, and so the correct ethical action may have been to ignore the law, but that doesn't mean that's not what the law was. I don't know if anybody made arguments like that, but that's sort of what seems to me like maybe a natural position to have if you're a positivist.
Well, that's exactly what you do with the separation thesis if you're a positivist. That's exactly it. But then the question is, what do you do if you're a natural rights thinker, if you're a natural lawyer, and you disagree with a law such that you think it is illegitimate? I guess we'll get a chance to talk about slavery then. So there's a guy named Lysander Spooner, one of my favorite thinkers from the 1800s. He was an abolitionist, and he was a radical thinker in just about every single area. And his position on slavery was that slavery was unconstitutional. And this was a debate among abolitionists. Is slavery constitutional? Does the Constitution support slavery, or does it not? Is slavery legitimate, or is it not according to the Constitution? And actually, in Spooner's position, by that time, so he was writing in 1845. This is 15 years before the Civil War. So he's writing in 1845. His position is actually that the Constitution itself is illegitimate. He says, however,
sorry, this is Spooner, right?
This is Lysander Spooner, yeah. Very much an abolitionist at this time, early on. And so his position was that the Constitution was illegitimate for a whole bunch of reasons. But suppose, he said, that the Constitution is legitimate. Like, he's talking to his fellow Americans. He's saying, in that case, slavery is illegitimate because slavery is unconstitutional. And so then, that then opened the question to him and to everybody else who was convinced by him, including Frederick Douglass, by the way. Frederick Douglass was convinced by his arguments that slavery was unconstitutional, and that allowed Frederick Douglass to then argue that the Constitution, the Declaration of Independence, and the founding generations were all good guys who were very much against slavery, and that was very much a part of Frederick Douglass's shtick. Well, anyway, so the question for Frederick Douglass and all Americans who were convinced by Spooner, as well as Spooner, is what do you do with the fact that you now know that slavery is illegitimate according to the Constitution? What do you do as a slave owner? What do you do as a non-slave owner? What do you do as somebody who is on slave patrols? What do you do as a police officer, as a president, as a judge? What do you do in all of these circumstances once you know that slavery is illegitimate? Huge question. And so Spooner, of course, had an answer for all of this. And his position was basically your duty in those like where you are in your life is A, do not support slavery, B, undermine it as much as you can. And his, like, first of all, he was, forgot if he was a backer or a supporter or something having to do with the John Brown raid, which was this major scandal, like anti-slavery scandal. He was very much a part of that. But I think his biggest contribution in this area was like, what do you do if you're a judge? Or what do you do if you're a jury member? And you're like, the question is, do you uphold some sort of a slave code or not? And his answer is, of course not. And that's why he argued for jury nullification. Like the jurors would look at a statute and say, in this circumstance, we are not going to apply this particular law. Like it says something very clear, not applying it because it's illegitimate. And so he argued for jury nullification, the jury nullifying, like saying no to that particular law. And he would say the same thing for judges. And there were bits in Spooner that were like really difficult. Like, what if you're a judge but you're a positivist? Like you think the law is the law, it's what it says. Then his position is, okay, resign.
Why? Explain that. Why is that? Why not? Why wouldn't Spooner's position be stop being a positivist because you're wrong? I'm
actually not sure. I would imagine that he probably argued something along the lines of, you should be a natural rights thinker. But if I don't convince you, then you should resign.
Rather than uphold this this illegitimate, illegitimate law.
First, do no harm. Second, end slavery.
No, Well, I guess the question I have. Well, no, go ahead. Make your point.
Well, I was just going to conclude that really the point is, if you're a natural rights thinker, if you think that like so much of the law is morality, then you do what you need to do in your particular area of life to really like oppose the illegitimate laws and support the legitimate laws.
What I was going to say though is, if you're a positivist, then if Spooner has convinced you that that slavery is actually unconstitutional, so not that it's illegitimate for moral reasons necessarily, although I'm sure he believed that as well, but that it's actually unconstitutional against the actual Constitution, then as a positivist, shouldn't you also think that you shouldn't uphold slavery just because it's actually against the letter of the Constitution, assuming you buy into whatever Spooner's argument was for why it's actually unconstitutional?
That's a really great question. I'm not really sure what his particular answer would be in his time. I didn't get to that part of the debate. I I could, though, say something about what would you do in that circumstance? You could actually okay, you're a positivist. You think that slavery is unconstitutional on positivist grounds. You could still justify upholding slave codes. This is wonderful. On the basis of, this is just what we do. As a community, like our community, our legal community, my co-judges and the Supreme Court and all these people are upholding slavery. We may know that, like, according to the framers, according to the Constitution, slavery is unconstitutional, but this is just what we do. And that really goes back to, again, my definition of law. Law as an institution that lives and grows with us. That's actually what law is. It comes out of this thing that we do that looks like law.
Wouldn't that be wouldn't that be anti-positivist, though, to think of that as the law?
Yeah, I think so. I think it could, however, be justified. For example, after Dred Scott, for example, especially after Dred Scott. That was a little bit later. That was 1857. But still, like, if you have a Supreme Court, the top dog, saying slavery is legitimate, it's constitutional, it is what it is, and everybody else is following it, then that's the positive law. Why? Because even if the Constitution, like, let's say in the Constitution it says thou shalt not slavery. Let's say that says that in the Constitution, but then the Supreme Court says thou shalt slavery. Mm-hmm. That's one source of positive law. Constitution is another source of positive law. And you could just say, hey, the positive law is telling the Supreme Court is interpreting the Constitution in such a way that the Constitution says that slavery is legitimate. I think you can run logical pretzels all throughout all of this. That's kind of the nature of the law. But that's really what I think a positivist would say if they're just uncomfortable. Like in response to Spooner, yes, Constitution says that that slavery is unconstitutional. In response to him, if they're still uncomfortable saying no to slavery, that's the kind of argument that they would probably make.
So maybe something like, as a judge, I have to maybe like accept some interpretation of the Constitution, and that interpretation is positive law itself, right? So I want to ask you one more broad question. So I know that from conversations we've had before, you don't quite consider yourself either. Is that right?
No, I do not. Mm-hmm. Neither positivist nor moral whatever is.
Mm-hmm. Mm-hmm. So yeah, so what's your stance on this then?
Yeah, I'm Hayekian.
Okay, great, awesome.
Yeah.
Okay, so
you're welcome.
That's exactly what I wanted to get to. So what is this? What is like Hayek's kind of like third way approach to this question?
Hayek had a third way, and he focused a lot more on custom. I was talking about like morality and custom being like something that is an alternative to positivism. Well, Hayek was very much explicitly non-moralist. And in fact, I recall him being anti-moralist. Like he's like, please do not bring in morality into anything. He was very much against morality, like generally. Not that he was immoral, like he had a legitimate, strong moral compass. Rather, he just didn't think it was particularly useful for social science, all that sort of stuff. Like leave morality out of it. It's too complicated. So he really focuses on the law more as a social institution, one that emerges out of life, out of society. And so he looks at law as something that is customary. I tend to think of the law as not just customary in the like really informal sense. I tend to think of law as formal, informal, and everything in between, like this big spectrum of the rules of the game and how they like play with each other over time, over the course of history. This focus on law as customary, emergent, evolving, constantly changing, and as what is the law, I think really it doesn't really solve any of the big debates in the world of jurisprudence. And we've only been talking about one, and there are so many others. We've just been talking about like the big one, or one of the few big ones. Hayek doesn't really solve anything, but he really illuminates all of the debates. And the way I like to think about it is that these categories of natural rights and positivism are rather abstract, and he takes them and he grounds them in just social human action. This is the thing that we do, this thing that is law. And once we start thinking about it in this both simplified and complex sense, like it's like the Hayekian view is, I think, both simpler and in a sense way more complex than any of these abstract categories. Once we start thinking about it, I think we start thinking about law as something more realistic, something that has like significant flaws, just like the rest of human society. I guess that's my teaser for Hayekian jurisprudence.
It kind of sounds like it's descriptive, sort of like the positivists, but rather than treating it as descriptive in terms of what's written down, it's descriptive in terms of how do people actually behave? Like what are the actual norms that people seem to be emerging out of how people actually interact with each other on a social level?
That's right. Yes. So that's the descriptive angle. Then there is ironically, the moral angle. What is the law? What is morality? There's like, what is moral? And I think that Hayek has, oh, by the way, for anybody watching this, Hayek, this is F.A. Hayek, Friedrich von August von Hayek, von August Hayek, August von Hayek, whatever, F.A. Hayek. Nobody knows. F.A. Hayek is a great economist, social thinker, legal thinker, whatever.
Also,
love the guy. He's my favorite thinker.
For anybody who's watching this on video, also, he's also this guy on my shirt, but that's
planted purposefully. He emerged just like the law. Okay, so in like for 20s, 30s, and 40s, he was like really big on economics. He ended up winning a Nobel Prize in economics, and then after a while, he just started thinking, "Wow, nobody agrees with me on just about anything." And so he thought, "Why don't I go into a completely different area of thought? Let me write a whole bunch of treatises on the law." And so in the 60s and 70s, that's really what he was doing. And I think he's a total pioneer, just an amazing thinker. And I think he really illuminates just about everything that anybody has ever said in the world of jurisprudence with his idea of emergent law, that law just emerges just like language emerges out of society, just like prices emerge out of society. And that's what I think is really cool about the morality of his system. Because although he is anti-moral, I think that what his system allows is the emergence of justice. Like, what is morality? What is justice? It is something that we as a society allow to emerge out of ourselves through this institution that we call the law. And if you like really follow Hayek's prescription, like in my opinion, if you like take Hayek and apply him to how the law should be done, how constitutional law should be done, whatever, what will emerge is the closest thing to justice that we could possibly come up with, because it's kind of like unleashing like what we really want as a society. That I think that's really the end goal, or really what is promised as the end goal of Hayekian jurisprudence, the discovery of justice.
Yeah, that's fascinating. It's kind of like and it seems like a kind of like, how do I put this? The law as like a social sort of self-expression almost, if that makes sense. Like it's if you look at at social action cumulatively, one way in which it sort of expresses itself is in the legal norms that arise out of it. And there's a meta-ethical position implicit in that. I think that's sort of what you're getting at.
Yes.
All right, Mike, thank you so much. This has been really fascinating. I'm going to have to have you come back at some point to discuss other issues, since we only really talked about one. But yeah, thank you so much. This has been awesome.
Thank you. I had an awesome time.
And that concludes today's episode of Who Shapes the Barber? Again, I'm William Nava. You can check out other episodes, as well as my other philosophical and artistic work, at williamnava.com. And if you'd like to subscribe to this podcast, go to williamnava.podbean.com. Thank you so much for listening.